I'm Ken Irwin. I'm with White & Irwin Shealy and Associates. Our firm's been working with Indiana County governments since 1979. We specialize in human resources administration, developing personnel policies, job descriptions, compensation studies, operations reviews. But one of the things that probably keeps me most busy is when I get the calls from the auditor or the HR director, the attorney, and you're not going to believe what happened today in our county. And then they tell me this long story about some crazy thing that happened at work, and they always end by saying, I'll bet this doesn't happen anywhere else. And I go, oh, I think you're wrong. I'd like to take a second and go around the room and have everyone just kind of introduce yourselves and, where you're from and what you're doing, and start over here on the left. Very nice. Good cross-section representation around the state. I know there were some other people who would have liked to have been here today, but given the weather and some of the snow in some places, but I see we get people here from St. Joe and Jasper. You're all used to snow and Elkhart. I think the message here today is, trying to put together standard personnel policies in county governments like herding cats. And it's partially due in part to the fact that policies in county government, we've got this kind of the beast of county government with all the various elected officials, department heads, the courts, a prosecutor, sheriff's department, a lot of different jobs, but we've also got a lot of heads of departments that too often are kind of taking the approach of nobody's the boss of me. And we don't really need the commissioners or HR, the auditor interfering with what we do. And to some extent, there's some truth in that the elected officials do have the hiring authority, they do have the disciplining authority, promotion, and so on in their individual departments. But there's also a number of federal and state laws and rules that all of us need to follow, and Tim pointed out a number of those earlier. There's the Family and Medical Leave Act that's a federal law. It's enforced by the Department of Labor and really needs to be administered in a standardized way throughout the county, regardless of which office or department that you're in. Same for the Fair Labor Standards Act, which we're going to spend some time with here this morning. Americans with Disabilities Act is going through some changes, and there's kind of a little bit of interplay now between the Family and Medical Leave and the Americans with Disabilities Act. One of the crazy things that happened at work just recently, December 25th, it appeared in the Herald Bulletin in Anderson. Court rules commissioners exceeded authority. An Indiana Court of Appeals ruling in Madison County case could have long-range effects on local government in the state. The Court of Appeals ruled that Madison County's commissioners and the Madison County Council had no authority to sign a collective bargaining agreement interfering with the independence of the elected officials. How many of you have collective bargaining agreements in your county and in some office or department? Anybody? One? Okay. Quote, "We conclude that the commissioners and council, by entering into a collective bargaining agreement, exceeded their authority and encumbered the officials' right to appoint and discharge their deputies and employees," the court wrote. In most of Indiana's 92 counties, officials are elected to specific offices, including the sheriff, treasurer, clerk, assessor, recorder, prosecutor, judges, coroner, and surveyor. Last January, Grant County Judge Warren Haas, serving as a special judge, issued a ruling that collective bargaining agreements signed by the Madison County Board of Commissioners and Madison County Council were not binding on elected officials. The United Auto Workers Local 1963, representing Madison County employees, filed an appeal with the Indiana Court of Appeals seeking to have the collective bargaining agreement pertain to all elected officials. The Indianapolis attorney wasn't available representing the UAW. Madison County Assessor Larry Davis and Recorder Angela Shelton were elected in 2010. Prior to beginning his term, Davis notified 5 employees who would be relieved of their positions. The UAW filed a grievance with Davis and Shelton, charging that they violated the terms of the collective bargaining agreement. The commissioners requested that Davis reinstate the 2 employees, a request that he refused. Shelton, in March of 2011, terminated an employee for performing substandard work, and the UAW filed agreements that she has violated the collective bargaining agreement as well. The judge determined in his ruling that the commissioners do not have the general employment authority over elected officials, deputies, employees. The Indiana Court of Appeals determined that the commissioners only have hiring authority over a position spelled out in state statute, and if that the case, it would prefer, if that was the case, it would refer statutes empowering the appointment power of other elected officials as meaningless. In the present case, UAW ardently insists the commissioners, rather than the officials, have the authority to appoint and discharge deputies, and we agree, the opinion states. Now, the fact of the matter is, this is a very narrow case in terms of it's a collective bargaining agreement. It's not talking about other personnel policies that the commissioners of the council may have adopted. And to some extent, it's understandable that there is some ruling here where there was interference with the ability to hire or discipline or discharge employees in those elective offices. But I think what begs the question is the authority for setting other terms and conditions of employment. For example, the county council has the authority under Indiana Code 36252 or 253 to set the compensation of all county employees. What about the courts? What about the prosecutor? What it says is the county fiscal body shall fix the compensation of officers, deputies, and other employees whose compensation is payable from the county general fund, county highway fund, county health fund, county park fund, recreation fund, aviation fund, or any other fund from which the county auditor issues warrants of compensation. Any other fund. So if you're being paid by the county out of a fund that the auditor issues a warrant, you're subject to the council setting compensation for that employee. The council also has the authority to fix the number of officers, deputies, and other employees, describe and classify positions and services in a job classification scheme, adopt schedules of compensation, and one that our firm likes the best as part of the law, hire or contract with persons to assist in the development of those schedules of compensation. So they can hire outside consultants to implement those pay policies that they adopt. Well, you lay these two beside one another, does the assessor, does the recorder have the ability to say how much someone gets paid? And I think the answer is pretty clear, no. They can only pay as much as the salary ordinance established as the highest paid amount for that position, and the position has to be approved by the council. So again, this ruling, we're not, the ruling, I think, makes some sense in that we're not, in any policy that I've ever worked on, we're not telling elected officials or department heads who to hire. We're not telling them how they assign the work within their department. But what we do have in the way of some standard rules is this is the compensation for this job. This is the terms and conditions for being paid to be in this job, such as longevity pay. How many have longevity pay in their county? How many? If you have longevity pay, State Board of Accounts says fine and dandy. But you have to have a policy that establishes how that works. You just can't say, okay, Fred and Linda, I'm going to give you some extra money because you've been here a while. And, Bill and Joyce, I'm not going to give you any. That's discriminatory in itself, but there's got to be a policy that allows for that compensation to be paid to those people. Everything that basically happens in the way of policy and administration of policy has to be grounded somewhere. Somebody has to have the authority to do what they're doing, whether it be salary administration or benefits or hiring and termination. Now, I think in the Madison County case, this is not the end. It'll end up in the Supreme Court. And I've talked to the attorneys who worked on that case, and they still are taking the opinion that this is a contract. This was a contract that was entered into, and they believe that the people who entered into the contract have the authority to do that, which, that will be up for debate. I think the broader issue for us now is what implication does this have for county commissioners, councils setting personnel policies, preparing handbooks, adopting handbooks, those sorts of things. I know that one of the standard sections that we advise our clients to have in their handbook is to put in an exceptions clause. Wherever there is an exception to a state rule, that it'll be recognized. Otherwise, the policies that are in the handbook will prevail. So, again, it's advisable to have policies that are standard for all of the federal statutes that we have to adhere to in the way of personnel administration, as well as some of the state. There's also some other statutes in the Indiana Code that provide some authority for commissioners to establish policy. And it's basically where there isn't a specific statute for the assessor, then the commissioners can establish policy. The commissioner established policy over the work times. When the courthouse is open X hours for business, that's the commissioners. Had a commissioner call me last summer and said, can you find a statute that puts the commissioners back in charge of the county again? So what's the problem? Well, walked in the other day and it's about 10 o'clock in the morning and walking through the courthouse and there's a sign on the treasurer's office, closed for the day. It's closed? Yes. I looked around, there was people working in the auditor's office and every other office in the courthouse was open, but the treasurer's ticked off the council because they won't give her an extra help, so she just closed up for the day and sent her employee home. Well, that's fine. What about the person that just drove 40 minutes to come to the courthouse to do business and has a piece of that business to be done in the treasurer's office? What can we do? Well, there are statutes on the book that specifically say the office shall be open for business during these hours. And there should be some provisions for taking care of people when they would have to close in an emergency, if there's an emergency. But someone should be in that office to at least be able to greet the public that comes in and answer the phone. And there's usually enough people in the courthouse that know enough about what the other offices do to be able to cover to serve the citizens. But in this case, this was more of a political fight, if you will, that was internal, and the treasurer's trying to make a case that she can do what she wants to. And the commissioners ended up passing a policy that basically said if it's not closed for an emergency that we close, then people who are not working that day, sent home otherwise, will not be compensated. So it's really crazy sometimes. We have to get in these policies to try to manage what would be otherwise common sense kind of events in order to continue operations. In the handout that I've provided you, there's a excuse me, there's a number of items that I think we want to cover here today. On page 3, started out with a hypothetical, and these are all really designed to get some interactive discussion, getting you to thinking about what's going on. And at the end of this morning's session, start of the afternoon, if you have specific questions or topics that you would like for Tim and I to address in the afternoon, please slip us a note, with those questions, and we'll try to get to them before we end today. I've found that some of these workshops we've done, we rush through things and we don't have time to deal with some of the questions at the end, and there's always that lingering people that want to talk and didn't get some of their questions asked. So jot down some of those questions as we work through these scenarios, and if you have something you want to address, we'll do that after the lunch break. Hypothetical 1, what would you do? In a meeting of the county commissioners, the auditor presents claims for payment in the amount of $17,200 for compensatory time hours from 2 highway department employees, the highway superintendent and foreman. The employees are non-union supervisors and oversee all department operations, budget administration, and crews consisting of union workers. The auditor has no record showing how and when the comp time hours were earned. The employees want immediate payment and have expressed their intention to file a lawsuit if denied payment. What would you do? Brittany? You'd question, where's your time record? What do you, if it was approved? What else would you want to know? You would look at their job descriptions to see if they're exempt. What's that mean, Kim? Now, people who are supervising other people are oftentimes, not make too broad a statement, exempt from overtime or being entitled to any overtime. If you're holding an exempt position, or a non-exempt position even more, it should be defined in the job description somewhere. And that is the base document for you to look at. On page 7 of the handbook, taken from the Department of Labor Wage and Hour Division that enforces the wage and hour overtime rules, you'll see that we have these exemptions. People who hold executive positions can qualify for an exemption to the overtime rules. Now there's a salary test. You have to make $455 a week. That's the salary test, and you have to be paid on a salaried basis. I was reading an interesting article a week ago about how that hasn't changed since the Gerald Ford administration. $455 a week is somewhere around $23,000 a year as a salaried position. Now that was a lot of money maybe in the early 70s. That was a lot of money in the early 70s. I think my first teaching job in public schools in 1970, I made a whopping $6,500 a year. And they said, well, if you go out and get a master's degree, we'll give you a raise. So I'd better do that, and went out and got it. $77,500 raise for the master's degree. So the $23,000, that was a lot of money back then. But that hasn't changed. And this article that I read talked about this is something that could really throw the whole apple cart upside down. This is a change that could be, according to this author, changed by executive order by the president without Congress. And the suggestion was to make that number closer to $50,000 a year. Now we take that number as a salary test, and we're going to have a whole bunch of people in county government that have been exempt. I see some of them smiling in here now, who are now going to be eligible for overtime because they're not going to meet the salary test. And I would dare say that this will be a part of the debate in the coming final years of this president's administration. But beyond the salary test, which everybody meets now, the employee's primary duty must be managing the enterprise or managing a customarily recognized department. They need to direct the work of at least 2 or more full-time employees or their equivalent for part-time. The employee must have the authority to hire or fire, or the employee's suggestion has the ability. They make recommendations on hiring and firing, advancement. So these are people who are normally directing a department or a large operation. The highway superintendent in this case, and I don't know any county in Indiana that it's not, should be an exempt position. That's one that's not on the cusp. I don't think that's debatable anywhere, that the highway superintendent is exempt. Now, the foreman position, on the other hand, now that's up for debate. Now, the other exemptions on page 8, the second one is administrative exemption, same salary test, primary duty, performance of non-manual work, and the primary duties, the exercise of discretion and independent judgment with the respect of matters of significance. Now, that's pretty general. But the way the Department of Labor looks at this administrative exemption is very, very narrow. I think there's a lot of jobs in the courthouse we would typically say are administrative in nature, but many of them are not going to meet this test under the wage and hour rules to be exempt. The next exemption is professional. Again, the same salary test. Primary duty must be the performance of work requiring an advanced knowledge, defined as work which is predominantly intellectual in character and which includes work requiring the consistent exercise of discretion and judgment. They're applying their knowledge to the job that they've typically had to receive some kind of a formal education, baccalaureate degree, master's, or some certification to be considered for the professional exemption. The county attorney would meet this exemption. The county engineer would meet that exemption. But again, and you don't have to meet all three in order to be exempt. You only have to meet one of them. There's a new one that has come into play in recent time, and this is a computer employee exemption. Primary duty, application of systems, analysis and techniques, design and development, documentation, analysis. This is not always just the IT guy. You can call him director, but if he is mostly a help desk, if he's troubleshooting, those are standard, routine kinds of IT jobs. We'll often find those jobs to be non-exempt, but a person who is the head of an IT department that has some layers of IT people working in it may be the one job that would be designated as exempt. So again, very narrow in terms of that application. But the three main tests that you're going to find is professional, administrative, and executive in order to be an exempt position. Someone was telling me about, well, you know, they just decided to make everybody exempt because they don't want to pay anybody any more comp time. Just fairy dust, wave it in the air and let it fall, and all of a sudden, you know, we don't have to worry about overtime anymore. And that's really not going to stand up. In order for this to be, if it's scrutinized by an outside person, like the Department of Labor who investigates complaints, or if an employee takes this to a court, then the employer, it's incumbent upon the employer to be able to demonstrate how they've classified the job as exempt. And it's been my experience that there's a small layer of exempt positions in Indiana county government. So back to, well, a couple other things. Next page, just quickly, police officers, firefighters, paramedics, other first responders, those exemptions do not apply to them. Those people are going to be non-exempt. But for fire chief may be exempt, a police chief, sheriff, other elected officials are excluded. So elected officials are excluded from these overtime requirements entirely. In fact, elected officials, there's no work hour requirements. You don't have to come in if you don't want to. Now, voters may not like it, and they may want you to stay home permanently, but you know that's for the choice of the individual elected official. So back to our hypothetical, who's eligible for overtime or comp time? Kim's got it right on. You need to have a job description that specifies that for every job in the county. I mean, this isn't something that ought to be up for debate just on a whim or how we treat people or want to treat people, but should be rooted in a duties test made of the job description to make that call. So now we've said that the highway superintendent is exempt. So do we owe him or her any money for comp time? Well, on the face of it, no, we don't. However, what has been the past practice? What if we don't have the job description that says it's exempt? Here was the scenario in a real county, and this happened. They looked at the auditor and said, well, do we have money to pay these guys? Well, I don't know. I don't know where it's going to come from. What in the world? And the argument in the county was, look, Fred just quit last week and we paid him off. What was Fred's job? Truck driver. Okay. Truck driver is non-exempt. So if the truck driver has accrued comp time, it's earned and owed, and we've got to pay it. You have to pay it. But taking that example and saying now we have to pay the superintendent because we treat everybody the same, not right. Unless your county has had some policy that has allowed exempt employees to enjoy the same benefits as the non-exempt. And this happens. And you kind of scratch your head when you get that call. What do you mean you're going to pay this guy off? Well, that's why we've always done it. I'd like to have a dime for every time I've heard that sentence. That's the way we've done it around. I don't know why. It's been that way forever. Okay. Now, the Fair Labor Standards Act says you have to pay the non-exempts. But the Fair Labor Standards Act sets a floor and not a ceiling. If we want to pay exempts comp time, Department of Labor says, fine, it's fine. You've gone beyond what the minimum requirement is. That's fine by us. There's no problem. Generally, most county councils don't see it that way. Most any councilman here today? No? Yes? One? Most council pretty tight with the budget, the money around this state. Some of them I would say tight as bark. Hard to get money out of them, and particularly when 80% of the budget's wrapped up in salaries and benefits for employees. So it's not the common practice to be paying out overtime or comp time to exempt employees. But the county needs to have a policy, not just a job description, but also a policy in their handbook that explains who's eligible, who's not eligible, and how it's going to be computed, how that's going to work. So what is the policy and the rules, and what's been in place? And are there going to be people that these guys can point to if they can find there's somebody who's been in a like position that got paid out, so now we're discriminating against me. So we have to take the broader view and look at what has been the past practice. Accrual limits. Now, for non-exempt employees, comp time, the accrual limit is 240 hours for non-public safety, non-exempt employees. What's he saying? The limit for public safety employees is 480. 480 comp time hours is the cap. Now, the cap, these caps under the federal government are caps that's as much as you can get in the way of comp time. If you work overtime after that, you have to be paid monetarily. You can't award people, 241 hours of comp time if you're in a non-public safety, non-exempt position. So it really is a red flag when somebody says, well, Fred's getting ready to leave and he's got 380 hours of comp time. Whoa, we're already in violation. 240 is the limit. Got a question?
Does comp time have to be paid in time and a half, or can it be just regular time?
Good question. Does comp time have to be paid at time and a half or
Time and a half.
straight time or time and a half?
Right.
Okay, good question. See if I can confuse everybody. There's two flavors of comp time. Oh, geez, I'm confused myself. There is non-FLSA comp time. That's the comp time that we would give for hours between, say, 35 up to 40 in a work week. Straight hour for hour. Anything over 40 has to be at time and a half. So we're either going to have to pay in money time and a half, the regular straight time rate, or an hour and a half for every hour they would work over 40 in a work week in comp time. So it's really advisable if you've got employees that are working less than 40 to keep two separate buckets of time, because that second bucket is what the federal government regulates, the one they say 240. But in most of the time, if you're on a 35-hour work week, it's going to be under the 40. If you got a highway department, for example, that works over 40 hours a week, then anything over is going to be at time and a half. Now it's deposited at time and a half. I had this question yesterday. The guy says, I don't think we're doing it that way. Well, let's take a look. I work 41 hours. You put an hour and a half into my bucket. Okay? If I work another hour, you put another hour and a half. I got 3 hours in the bucket. And that accumulates up to 240. So when it's paid out, it's paid out at the straight time rate of those total number of hours. We don't have to do it twice. You've already given them the credit for the time and a half by depositing an hour and a half into that bucket. But when you pay it out, those 240 hours would be paid at their straight time rate. Do employers have to use the 240? Can we set a lower limit? The answer, yes. You can set a lower limit. What's the limit in Howard County?
We have 40 hours, but you can't go over 50 at the end of the year.
40, but you can't go over 50 during the end of the year, and you can't carry it over from one year to the next beyond. They've kind of got a half-calf, decaf with a twist with, something on the side. But well, I was talking to a councilman yesterday from Harrison County. He says, the auditor gave us a report. We got $55,000 in comp time on liability out there amongst employees, and we want to get that work down. So yes, that can happen. And too often we hear employees, well, what if we just passed a rule that says use it by the end of December or lose it? No, can't do that. It's earned and owed. The comp time is just there in place of money. I'm not going to pay you, so I'm going to give you some comp time that you can take off work, and I'm going to pay you when you're off work. So oftentimes we kind of get this thing, well, it doesn't cost the county anything to give comp time. Well, yes, it does, particularly if you've got a department that has to fill in for people when they're off on comp time. And you may be paying additionally to maintain staffing levels when people are off, as opposed to the cost of going ahead and paying monetarily for any overtime. Do you have to use comp time? No, You don't have to. In fact, this is only available to public sector employers. Private sector employers cannot use comp time as an exchange. It's only available for the public sector. Time records, anybody? Well, what's the FLSA have to say about that? On page 9, again, this is taken directly out of the Fair Labor Standards Act. Record keeping. The Fair Labor Standards Act requires employees to keep records on wages, hours, and other items as specified in the Department of Labor record-keeping regulations. Most of the information of the kind generally maintained by employers in ordinary business practice and in compliance with other laws and regulations. And they've got a list. Personal information, hour and day when the work week begins. We have to define what a 7-day work period is, when it starts, when it ends. Total hours worked each work day and each work week, total daily or weekly straight time earnings, regular hourly pay rate for any week when overtime is worked, total overtime pay for the work week, deductions or additions to wages, total wages paid each period, and date of payment and pay period covered. Sometimes it almost seems like you start looking at some of the records and these, when you get into a dispute when somebody's claiming back pay or overtime pay, the records are almost non-existent. It's like these regulations are just a suggestion that we're the county, we can kind of do what we want to do, and that's a recipe for disaster. We have the corner here from Lake County. Lake County's experienced a number of these Fair Labor Standards Act lawsuits. We have, well, kind of run through the list. We had the canine lawsuit where we were not, the sheriff, police department was not paying canine officers for care and grooming of the dog during their off-duty hours. Now the rule is you got to provide compensation for that or comp time for 365 days a year unless the dog's in a kennel. Well, there was a guy, I think it was in the Highland Police Department up there. He was a canine officer. He knew the rules and retired. And when he retired, he submitted a bill to the city and said, you know, you owe me $10,000. We what? You know, you came to us. Can I have a dog? I'll take care of it. You know, it's like a kid. Well, here are the rules. So they wrote him a check. Then he applied and received and was appointed to a sheriff's job in Lake County. And works another 15 years or so. Hey, you owe me some money. Except in their case, it wasn't just him. There were 14 other canine officers. So it was a matter of going back and computing all the back pay that was owed them in a lawsuit in order to pay all the back pay, which ended up with a number around $500,000 just on the back pay, plus the legal fees and the like. So these people know the rules, and sometimes I think they know the rules better than the managers of these departments. The second suit there involved, again, the police department, and they kept referring to this as the 5-minute lawsuit. 5-minute lawsuit? What's that? Well, we've got this requirement that officers coming on duty need to come in 5 minutes early to exchange information with the officers that are going off duty. Okay. But they're just going to volunteer their time to do that. Yeah, that's right. Well, you start adding up all those 5 minutes from every officer, and they've got a few hundred for 2 or 3 years, and you get another number. So then there was the payoff of the 5-minute lawsuit. Then the third lawsuit had to do with adding all compensation to figure the overtime rate. Well, what do you mean? Okay, if we're paying someone, let's just say $30,000 a year in salary, and they're non-exempt, and let's say that longevity pay that you pay out, let's say that comes in a separate check, and let's say that officer gets $3,000 in longevity pay. Okay? In their scenario, they also had another added pay, which was called proficiency pay. And let's say they got another $3,000 for proficiency pay. They were on some special training unit, SWAT team, scuba divers, whatever. So now they've got an additional $6,000 beyond that 30. The overtime rate has to be computed on the 36, not the 30. That wasn't happening. Another big checkbook, another $500,000 or so for that lawsuit. And believe me, these people in these departments around the state, they're attuned to all this. They talk to each other all the time. They know what the rules are. And sometimes our county records are so bad, you really can't figure out when somebody earned overtime, when they took it. And this needs to be an ongoing communication. Each payroll, you earned 10 hours, you took 2, you got a balance of 8, just like you do vacation or sick days or anything else. So that you've got this running balance, and you've also got a policy in your handbook that says if you ever have a problem with your pay, if direct deposit wasn't correct or your check was not correct, you need to immediately contact the auditor and get this fixed, and we'll make sure it's fixed. That's your defense when somebody comes in and says, I've got 800 hours of comp time that I owe. No, wait a minute. No. We gave you a record of how much comp time you had, and you signed off on your timesheet as it happened. So that's going to be pretty strong evidence that this was the policy. You knew what the policy was. This is how it's administered, and it all is connected together. Excuse me. Otherwise, we get into this he said, she said, that was under the old sheriff. We don't do it that way anymore. We get, got a fire department. We give all of our guys 90 hours of comp time January 1. Why? Well, it's the way we've always done it. It goes back to when, Fred was the chief, and that's just the way we've always done it. And the guys like it. I'll bet they do. What if the firefighter quits in February? Well, that's happened before, and we've had to pay him off. So you're giving the comp time in advance. Yes. To take care of the scheduling through the year. Now, check this out with Department of Labor and others. Is it legal? Yeah, it's legal. You can do it. But you better have a good record-keeping system that shows that this is in place of overtime throughout the year. Is it a good idea to pay them up front for the whole year? Not in my view. I convinced the mayor that maybe if we did this by the quarter, it would lessen the impact of somebody leaving and getting paid out a lot of time here in the first part of the year. So that's the change. But where's your timekeeping? Do the employees see it? No, I just keep a record. We're on the honor system. I think, okay. That's kind of hard to defend. So that's hypothetical number one. And what is the law? And for our purposes here today, I've just gone into the Department of Labor website and cited the wage and hour rules in this reference guide that I think can be useful to you. It starts on page 4. Page 5. Sometimes people think that the Department of Labor wage and hour rules apply to a lot of things that they do not. And here on page 5, they've listed those. You know, for example, the Fair Labor Standards Act does not require vacations, holidays, severance, sick pay. Well, I think federal government they have holidays, don't they? Don't they have federal holidays? Yeah. Do we have to have a federal holiday? If you want to. You don't have to. So there's no rule that says you have to provide holidays, or there's no rule that says you have to provide vacation time or severance or sick pay. Those are all individual policies that every employer can decide for themselves whether or not they want. The FLSA doesn't say you have to have meal or break times. Well, you have to have breaks. I've had this happen in a lot of counties where you get the employees to well, you have to give breaks. That's the law. No, it's not the law. Is it a part of a lot of collective bargaining agreements? Yes. That's usually the first thing that's negotiated is some break time or meal periods, but it's not a part of the law. Does the Fair Labor Standards Act require pay raises or fringe benefits? No. It doesn't have anything to do with discharge, et cetera. Who's covered? Just cite public agencies. The public sector is covered by the Fair Labor Standards Act. So all counties, regardless of size, are covered. The same coverage is also extended to county government under the Family and Medical Leave Act. You're automatically covered. Now, these laws have had exceptions for having the X number of employees in the workplace, 50. Well, there's not 50 employees in the auditor's office, so the auditor's office does not have to provide family and medical leave. The auditor's office is one office in county government. It's the county as a total aggregate, not just the auditor's office, which was the argument in a case, I think, out of Wayne County. Exemptions, we've talked a little bit about those. We've got these executive, administrative, and professional exemptions. And then we've got some partial exemptions. On page 6, partial exemptions from the overtime pay. Public fire departments and police departments may establish a work period ranging from 7 to 28 days in which overtime need only be paid after a specific number of hours in each work period. Basically, for police, you can establish a 28-day work period, and the police would not earn overtime until they worked 171 hours. Fire departments, I believe it's 214 in a 28-day work period. The reason it's higher for fire is because of the 24-hour time in the the sleep time that's built into that schedule. But this essentially gives police 3 additional hours a week that before they owe overtime. So if you did a 7K exemption for police for a 7-day work period, they could work 43 hours before you would owe them time and a half. But the only 2 positions that I believe are going to be eligible for that exemption in Indiana county government is going to be sheriff's merit police officers and correction officers in the jailers. Dispatchers are not eligible for this exemption. They have to be paid at time and a half after 40. Would we normally think of them as public safety? Sure we would. But under the definitions of the FLSA, they do not fit the criteria for being put on this 7K exemption. Do you have to use it? No. But it is available as a method for computing overtime. Keeping. On page 10, we talk about the work week. You have to establish this work week period. You need to establish the hours that are worked. Is the lunch hour paid or not paid? In Madison County years ago, there was a Department of Labor investigation where the wage and hour people came in and reviewed the timekeeping practices and the overtime payment of all employees in the county. It was all triggered by 3 employees who called the Department of Labor and says, "I'm not being paid properly." Well, what's wrong? Well, we work full-time at the jail and we work part-time security in community corrections. Okay? They're not bringing all of our time together. They're not paying us the overtime for that extra time we're working over here in community corrections. Well, the county argued at first, those are 2 separate departments. It doesn't matter. That one's under, community corrections, out of the courts, and this is a sheriff's department. Department of Labor says, no, you're county employees. You get a county check. You have to bring all the time together, and if you go over 40, you're going to have to pay time and a half. Well, they weren't doing that. Well, the investigator didn't stop there. Well, if there's a problem there, there's got to be a problem in the courthouse. So I'm just going to have every elected official and every department head reconstruct their time records for the past 3 years for all the current employees and former employees that were working during that period. And again, payroll records, timekeeping records being what they are, that was a chore in and of itself. Plus, after she got into this, she said, I'm going to meet with every one of these elected officials, make sure they're doing this right, and I'm going to interview them. And this is when the commissioner says, well, Kent, maybe we better hire you to sit in on those so we are responding in a way that might be appropriate. I said, okay. And there's a couple elected officials that are in there and say, well, you can find whatever you want, Miss Frazee, but I'm telling you, I don't have any money budgeted for overtime, so I'm not going to be able to pay it. So, I mean, it's like telling the IRS that you don't have any money budgeted for any audit findings that they would make on your income taxes. And I mean, and this just spurred her on. Well, she became a tyrant with the next elected official that walked through the door and started going through their records. So, at the end of the day, it was like 2.5 years later, there was payouts to employees. The K-9 guy got his $13,000, and other employees got their payout because they had not put all their pay, they had longevity pay, which had not been added. She found that violation along the way. And while she's talking to them, she said, you ever had anybody on family and medical leave? We enforce that too. We never have. Anybody ever go to the hospital? Well, yeah, but we didn't have to put them on FMLA. Really? Anybody ever have a kid? Well, yeah. They on FMLA? Well, no. How's that work? And it's just like, how do you count time? You're here from 8 to 4. Yeah. Do they get a break for lunch? Yeah. How long? Hour? Is that paid or unpaid? 28 elected officials, and you get about 30 different answers to that question. So those are the kinds of things that need to be clear. They need to be spelled out in your policy so that we don't have this liability out there, that we have policies that are defensible and that employees understand. There is a 2-year, in terms of enforcement, this is all enforced through the Department of Labor. If they find a willful violation, they can tag $1,100 on each violation. And in Madison County's case, that would have meant times each employee. So now we're talking big bucks after a while. And at the end of that case, the investigator had every department head and elected official sign off on a certification letter that they would, in fact, follow the terms and conditions of the policies as they related to overtime. There's also equal pay provisions that are under this where we can't pay women less than men for the same job in the county. Then there's a fact sheet on local government that I've put in here, and it talks about the coverage, and you'll see on page 14 is the reference to the comp time and the comp time hours. And we end up on 16 with a quick quiz that we'll run over here before the lunch period, and we'll stop after this is over. Some of these maybe we've picked up along the way. Number 1, longevity pay or other extra pay, such as performance bonuses, on call, or shift differentials, does not need to be added to the straight time hourly rate when calculating overtime. The answer is false. The Fair Labor Standards Act requires that non-exempt employees be paid at the rate of time and a half for the hours worked over 8 hours in a workday. False. Well, that's the way they do it at my husband's shop. Well, likely that's a collective bargaining agreement. It's the law. You have to pay after 8. It's the law. No, it's not the law. It's 40 in a work week. 3, if a full-time jailer in the sheriff's department works 40 hours in a work week, and same week works 12 hours security officer in community corrections, this sounds familiar, he or she is entitled to overtime at the rate of time and a half for the 12 hours over 40. True if what? True if they, let's look at 10, and let's make clear. Number 10, under the FLSA, only actual hours worked up to 40 hours in a work week are used to determine when overtime at time and a half is owed for time worked over 40. What's the answer there? Number 10. This is true. Actual hours worked. So what that means is if I worked 8 hours on Monday and I worked 10 hours on Tuesday and I was off on vacation on Wednesday and Thursday, and I worked 8 hours on Friday, am I due 2 hours at time and a half for those 2 hours earlier in the week? And the answer is no. I didn't actually physically work 40 hours. So back to number 3, if they actually worked those 52 hours, then yes, they would be entitled to time and a half. But any time they were off for a holiday, sick day, vacation day, that they didn't actually work, then that would not be counted to meet the threshold to 40. This is one of the places where counties have a variety of ways of computing this. Some counties have taken the policy that they're going to follow the Fair Labor Standards Act strictly. You have to work 40 before you get time and a half. Others have said certain times we will count as hours worked. Usually the first one that pops up is holidays. We will count the holiday as time worked. And it usually comes up when this time of the year, and well, the guys at the highway department are off for, 2 days at Christmas, and then there's snow on Saturday, so they're not going to get time and a half. True. If the policy doesn't count the holiday as time worked in the calculation. The other one kind of going up the steps is vacation time. Some counties count holidays and vacation time as hours worked in the calculation. Some count sick. Some count everything as time worked. Some count comp time as hours worked. Well, it should. I've always advised our clients, no. If you count comp time as hours worked for overtime, you're pyramiding overtime to get more overtime. Sick time, that's usually not counted, some count it. But you can't have a policy that does that. But without the policy, you can't pay time and a half without making those exceptions. You can only pay time and a half after 40 in a work week. Number 4, salaried employees are not entitled to overtime pay and comp time for time worked over 40 in a work week. It's kind of tricky. This is technically false. You have to be salaried and exempt, not just salaried. And that's a confusing term sometimes. Well, they're all salaried, so they're not eligible for overtime. There's a number of offices in the courthouse where we pay a deputy a salary. In the recorder's office, we pay him a salary. But that job is not exempt, which means if they work over 40 in a work week, we've got to derive from their salary a straight time rate to pay the overtime rate. Employees, number 5, are required to establish a 7-day work week for the purposes of calculating overtime. True. It can be any 7-day period. Number 4 was false. Just salaried alone does not entitle you to being exempt. You'd have to be salaried and exempt. So salaried and non-exempt are entitled. Number 6, employees have sole discretion in deciding when they take comp time off. This is false. You can schedule it off if they don't take it off. This is one of the few times that the Supreme Court has ruled unanimously in the last 15 years. And this is over a sheriff out of Texas where the officers came in and say, well, Sheriff, me and my buddies, we're going fishing this weekend. 5 of us are going to take our comp time. So, whoa, can't let all you guys off at the same time. Well, it's our comp time. We can take it whenever we want to. No, you can't. You have to have approval. You should have policies for requesting use of it, but it has to be approved by the elected official or department head before it's taken off. And you can, if somebody's getting a high number of comp time hours up there, you can start scheduling it off to keep the accrual levels lower. Number 7, under the FLSA, non-exempt, non-public safety employees may accrue 240 hours of comp time before monetary payment is required. We covered this. That is true. Public safety 480, and you may set lower limits. 8, here's the canine guy. Canine officers and sheriff's departments are not entitled to any additional compensation for care, grooming, and training of the dog during non-duty hours. That's false. There's no set number, but you're not going to get by with less than a half hour a day unless there's some log of time. 45 minutes would be safe, an hour is better. Number 9, the Fair Labor Standards Act requires employers to maintain payroll records containing employee names, hours worked each workday, work week, wages paid, deductions, all that stuff that's in the regs, which is not a suggestion, that is true. Does anybody have any questions, comments over the, yes?
Yes, if an employee goes to training and that training goes over the 40 hours a week, let's say the training, you would pay them for 8 hours for the day on the training, but the training course is 10 hours long. Do you have to pay them for that extra couple hours?
The question is, if they go for training and the training is longer than their normal work day, do you have to pay for the extra time, like if they go for 10? The answer is yes. It's considered work. Like today, for non-exempt employees who would come here for a training session, the time would start when they left and it would end when they got back.
How about if they're spending the night for days and days, a week at a time?
What if they're spending the time, if they're gone for like weeks,
Or a week?
a week? Well, I know we had a guy in Kosciuszko that got there was a sheriff's deputy that got special training, went to Washington, D.C. for about 3 months and came back and claimed every hour that he was gone. No. There was a normal start time and stop time in the day of training. So we're not paying for, you're hooting and hollering at night with your buddies. It's just the time that you're in the training or the time you're in transit back and forth, but not.
I wanted to check because within the coroner's office, all our deputy investigators have to go to a 5-day training. So this is happening twice a year, and I want to make sure that I'm compensating.
Yeah, what time's the training start and when are you released to be on your own? So they keep track of that time they're in training. Good question.
Travel time, if there's 5 people going, do we pay for them all to ride in the same car? Who do we pay?
5 people are going to training, do we pay them all?
The travel time.
The travel time, I say yes. Do you have to? Probably not. Probably only have to pay the driver. But it's time, it's work time. It's time that, you're really on the clock.
And if it's after 5, say they work 8 to 5 and then traveling after 5 to the destination and spending the night there.
Well, whenever they arrive at their destination, if for example, you don't get back to South Bend until 6 and you're a non-exempt employee, It'd go to 6 o'clock as opposed to whatever your regular time would be. Now, how could we deal with that if we didn't want to rack up overtime? I mean, you could have a flex time policy with your employer that says, look, you worked over this day, take Friday afternoon, leave early by the equal amount of time, and flex the schedule within the work period. And that's something that's available too, that, you know, some people think, well, I have to work the same schedule every day. I think it's really advisable for policies to include a flex time policy that allows that to happen with the approval of the elected official and department head. Not the tail wagging the dog thing about, well, I went to the dentist and now, you know, I'm going to work over to, no, you decide in advance whether or not you're going to allow them to flex a schedule.